So imagine a multifamily unit. It's a small apartment complex. There are units on the bottom floor and units on the top floor. And there's a set of tenants in apartment 108. And they've got a problem. So they call up the landlord for a repair. And the landlord takes the call, gets the work order, and shows up. He does all his own repairs and heads over with his toolkit and is ready to go to work. He knocks on the door and the tenants let him in and immediately show him to a bucket. Now the bucket's there because there is a leak. And sure enough, he looks up at the ceiling and there's a brown spot on the ceiling and a drop ready to fall. And while he's there chatting with the tenants, sure enough, a drop falls right into the bucket. Now he's been doing this for a little while and his first suspicion is aquarium, because he had had a situation in the past where someone with an aquarium didn't recognize that there was a slow leak and dirty water was seeping out down the floor and actually into the unit below. So his guess was, I need to pay $208 a visit. That's exactly what he does. He said, give me a second. Before I get up on a ladder and start addressing this problem, I'm gonna go upstairs. Because in his mind, it didn't make sense that this was a plumbing issue. Why would a plumbing line be going in between the apartments? He was also certain this wasn't a roof issue because this was the first floor and not the second floor. And finally, he ruled out the possibility of an AC issue because the AC wouldn't in any way affect the bottom floor in this way. In his mind, he was convinced leaky aquarium water. So he goes upstairs and knocks on the door and nobody answers. So they hadn't made a request, nobody was expecting him, but he knocks again just to make sure no one is in there. When he gets no response after about a minute or so, he takes out his master key, opens it up, opens the door, and announces management. And nobody answers. But what he notices is a pretty strong odor. So he's convinced that there's been a flood, that the aquarium has broken and has flooded the living room, and he's gonna have a lot to clean up. And as he walks into the apartment, he discovers the source. It wasn't an aquarium. Unfortunately, the sole occupant of apartment 208 had ended things permanently and was lying on the floor. He'd been there for several days, and what was leaking through the floor into the unit below wasn't aquarium water. So naturally, the tenants in 108 were extremely concerned. This had been going on for at least a few days. They noticed the spot on the ceiling first, and once it began to leak, they called the landlord. But in their mind, they had been exposed to these biological elements for at least 3 days, and they were concerned. In fact, the moment they knew what was happening, they packed up their things and they left. Now, they certainly didn't pack up all their furniture, they didn't vacate, but they were not going to spend another night on the premises. Meanwhile, the landlord had a huge mess to deal with upstairs. The fact that this particular tenant had ended things the way he did left quite a bit of work for the landlord, and he wasn't exactly sure how to deal with this. Certainly the authorities were involved and had to become involved because this was not something you could just clean up and do away with. And what he found was that he had to have a professional service to come in and clean the unit in a way that isn't normal, that's specific for this kind of incident. And not only did the upper unit have to be cleaned, there were issues in the lower unit that also had to be cleaned, which he took care of and eliminated the problem 100%. Except that that really wasn't the case in the minds of the tenants of 108. They kept telling him, we don't feel safe here and we don't want to continue our lease here. And so the battle began. Did the tenants of 108 have a rightful claim to terminate their lease early, or at the very least to demand to be moved to another unit there at the apartment complex? Secondly, what was the landlord supposed to do now with the stuff left behind by his former tenant in 208? No one was designated in his lease. There was no one he could contact, but he had an apartment full of stuff and no one to send it to. So let's talk first about the rights of a tenant to terminate a lease in the middle of the lease when no one really is at fault. There are certain situations where the law will allow a tenant simply to vacate. These are statutory rights that are present in the Texas Property Code and give a tenant in certain situations the right to simply pack up and go. Now, this means that they'll have no harm from the contractual obligations that are otherwise present in the remainder of the lease. In fact, they are generally due a pro rata refund of the prepaid rent for the given month and a full refund of their security deposit. Among these statutory rights are the rights to terminate due to family violence, due to certain sex offenses or stalking, of course, due to death, and due to military deployment. But these aren't the only statutory provisions. Right beside me is a list of numerous other provisions in the Texas Property Code that would allow a tenant to simply unilaterally terminate their lease, again, if these situations are present as stated in the Property Code. Now, that's not the only way that a tenant can unilaterally terminate a lease with a landlord in the middle of a lease term. Of course, a landlord and a tenant can enter into an agreement and modify the lease and end it early if they so choose. And they don't need a statutory basis or any of these particular situations to apply for them both to agree that a lease will come to an early end. But finally, the last way that tenants terminate leases is the old-fashioned way, by simply packing up and leaving. And without regard to whatever damage calculation a landlord might have, from time to time a tenant will simply pack up and go, whether the statute says they're allowed to or not. At which point the landlord is left to calculate what damages they've incurred and whether or not they're even going to go after a tenant who has breached their lease by unilateral termination without any justification in the law. As I tend to recommend to landlords, if there's no reasonable capacity to recover these losses, you're probably just better off closing the book on this one and moving on to your next tenant. But if in fact the landlord does have a reasonable expectation of recovering these losses from a tenant who is otherwise able to pay, just chooses not to, then by all means, that landlord does have the right to file a lawsuit against that tenant and recover any of the losses for a terminated lease that was ended without just cause. Now, with regard to that tenant up in 208, what could have happened and how should the landlord have dealt with this way ahead of schedule? Well, the Texas Property Code allows a landlord to offer to the tenant an option to designate an individual who, in the death of the only named tenant on the lease, that person would take charge of the personal property left behind by that one tenant. In fact, I tend to recommend to all landlords to set out a form in front of your tenant and say, please designate at least one party who I can contact in the unlikely event of death in the middle of a tenancy. Because believe it or not, all of us are going to die, and sometimes, a few of us anyway, will die in the middle of a lease term. And because it can happen and you can prepare for it, you really should every single time. So when the sole tenant passes away and there are no other tenants who can take the lease, the procedure for the landlord is either A, to pack everything up and store it, or, which I really wouldn't recommend, or the landlord can call the designated party and have them come and pack everything up and take it. So when you have a designated individual signed and authorized by the tenant, the landlord can simply, again, store everything and wait for them, or call them up and wait for them to come and get the stuff. But the landlord's only required to wait a reasonable amount of time. If rent is paid for a given month and you're giving to the end of the month for a tenant to for a tenant's personal property to be collected by a family member, and they've got 2 or 3 weeks left in that prepaid month, well, taking that full time is okay because it's already prepaid. But once that prepaid month ends, it may no longer be reasonable to wait 2, 3, or 4 weeks, because all of that means lost revenue for the landlord. And if already there's a depleted security deposit, not only is there going to be very little to have to refund, but ultimately that landlord could start experiencing a financial loss. And so it's up to the landlord to hold that individual liable for a reasonable amount of time to come and gather the personal property of the deceased. Now, if the landlord has failed to request this designation from their tenant, or if the tenant failed to simply volunteer a name to the landlord for this particular occasion, then you're kind of left by default with normal abandonment rules. And so hopefully your lease, if you're in this situation, has an abandonment procedure, because if it doesn't, then you're going to have to try to figure it out as you go. And this is exactly where landlords find themselves in all sorts of trouble. Either they act too quickly, or they wait too long and end up losing a ton of money in the process. If you're in a gray area, go out and find somebody who understands the law and knows what is required. Remember, you're not required to wait an unlimited amount of time for someone to simply appear. You should have a designation in your lease, but even if you don't, there are ways for you to notify a next of kin that personal property remains and will be discarded if not collected within a reasonable amount of time. Now, what if in fact the landlord had supplied the tenant with a designation form and the tenant failed to fill it out and indicate who they had designated as the person who would be obligated to come clear out his stuff in the event of an untimely death? Well, when this occurs, the law says that the landlord has zero liability for that stuff if the tenant could have done it and did not do it. Once that time limit is up and there is no one coming, then the landlord can, again, if you've got prepaid rent to the end of the month and nothing beyond that, the landlord can technically simply dispose of the personal property, clean out the unit, and re-let the property to a new tenant. Again, if you are unsure whether or not that's your situation or whether you have that authority, come see a licensed real estate, or specifically a landlord-tenant attorney, or go find someone who's done this enough and understands the law and these processes. But certainly your best bet is to get ahead of it. In fact, if you're in the middle of a lease, you can supply your tenants with this form right now and have them fill it out so that you're not left in the dark. Now, back to the tenants and the apartment community. In this case, the situation was so complicated that it was a lot easier for the landlord to simply say, listen, I get it, you're not comfortable here, you may never ever be comfortable here again. I've done everything reasonable, we've cleaned it out, I used the special team with the masks and the hoods and the equipment to come in, and it's no longer a biohazard, that's for sure, but that doesn't mean your opinion of the place isn't forever damaged. So let's talk about a mutual termination agreement, and that's exactly what the parties did. They got together, they mutually terminated the lease, the tenants were able to move their things out without real consequence because they did it within that first month, and because they were able to do that, nobody was sued, and so they moved out. Eventually they got their deposit back because they hadn't damaged the property, but we were able to repair a situation in a way that made sense for both sides. Now, understand that generally speaking, the fact that somebody died next door or upstairs is not in and of itself the basis for a lease termination, but it might serve as a basis for mutual termination between the parties, as a customer service thing, or simply because your tenants are never going to be happy there. By moving on and not holding them to it, you're going to relieve yourself of somebody who's going to be looking for a way to get out, or possibly someone who's just going to pack up and leave anyway. At least this way, by planning it together, you can proceed, maybe even list the property and proceed without the complications of just a straight breach. Yeah, death is one of those things that we don't like talking about, but that we all at some point are going to have to face. And when it comes to our tenants, it's healthy to have this discussion, albeit uncomfortable. You'll eventually get used to it. That form is a simple form that you simply put in front of your tenants and simply say, look, it's probably not going to ever be needed, but just in case, please designate somebody that we can contact in the event of an untimely death. It's simple, it's easy. You do it as part of your lease signing paperwork, and you are done. That way, in the unlikely event that you ever have a situation like this, you're not left in the dark or scrambling for some solution. Additionally, you're not left with conflicting family members fighting over rights that you're not suited to resolve. If one person is designated, that's the only person you need to contact, and they're the ones who get everything. If the other family members want to sue that individual, they can do that, but you don't have to be part of it. So make it simple for yourself. Be upfront, or if you haven't done it already, put a form in front of your tenants and say, this is something we need to take care of right now. Again, not because I expect it to happen, but because it eventually will happen to everybody. It may just not happen during this lease term, but you want to be prepared. Landlords, I hope you learned something interesting. I hope that if you liked it, you give us one of these because we always appreciate that. And any questions or comments, leave those for me. I like responding to them personally. And if you haven't subscribed yet, please consider subscribing. Naturally, we're gonna welcome you to check out this video, which YouTube seems to think is the next best thing for you to check out. But we've got a library of all sorts of other topics of videos that we think you'll enjoy. Take advantage of that, and until next time, landlords, happy leasing.